Hello, everybody. Welcome to the 2020 Scalia Lecture, Who Needs Foreign Law by Ann Glendon, who is the learned hand professor of law. I'd like to take a moment to extend a warm welcome to Mary Ann's family who are here today, her daughters Sarah Hood and Katie Lev. So thank you very much for being here. I'm going to say not many words, some words about the lecture, about its namesake, and about the person who is here to deliver it today. Okay, so let's start with the lecture. The Justice Antonin Scalia Lecture Series was established at Harvard Law School in 2013 by an anonymous donor to promote and advance understanding of the founding principles and core doctrines of the United States Constitution. Speakers are drawn from the fields of political science, history, philosophy, law, government, religion, and related disciplines. The person chosen to be the Scalia lecturer is a scholar or figure of high distinction who, through their work, research, writings, and teachings, elucidates the principles of the American founding. Now, it is personally very meaningful for me to be able to be here to introduce the Scalia lecture. Justice Scalia was, of course, a very influential justice who changed the way lawyers and judges think about statutes and the Constitution. He was also a friend of Harvard Law School. When he passed away, my predecessor, Martha Minow, recalled Justice Scalia's, quote, terrific sense of humor and his, quote, great personal warmth. She recalled that he returned here to his alma mater often, quote, to meet with our students, to judge our moot court competitions, and as he so loved to do, joust with law professors and students alike. I know that he loved all of these visits and always provoked lots of lively discussion while he was here. Let me add that as one of Justice Scalia's law clerks, I got to know him well. He loved the law school, he loved the law, he loved ideas, and perhaps above all, he loved to mix it up. That's how he learned. And he would have loved to be here today, I'm sure, to listen to his friend, whom he admired very much, Professor Glendon, partly at least disagree with his position on the use of foreign law in constitutional adjudication. Okay, now on to our speaker. Professor Glendon joined the Harvard Law School faculty in 1987. She is a distinguished and internationally known scholar and teacher, particularly in the area of comparative law. She writes and teaches in the fields of human rights, constitutional law, and political theory. She's a member of the American Academy of Arts and Sciences, the International Academy of Comparative Law. She's a past president of the International Association of Legal Science, and of course, a former U.S. ambassador to the Holy See. Professor Glendon is the author of many pieces of scholarship, including the critically acclaimed book, A World Made New, Eleanor Roosevelt and the Universal Declaration of Human Rights. In 2006, she was awarded the National Humanities Medal. Throughout her career, Professor Glendon has been a scholar not only of great importance, but of great principle, someone who listens carefully and generously to every side of an argument. She is also incredibly collegial, thoughtful, and kind. I'm very grateful to be her colleague, and we are delighted to hear from her today. And so without further delay, it is my pleasure to introduce our speaker, the 2020 Scalia Lecturer, Professor Ann Glendon.
Thank you, Dean Manning, for that very kind introduction. And sometimes it does feel like I started in 1880. I'm also grateful to you in the Scalia Committee for asking me to participate in this wonderful series, which you yourself inaugurated. And you were followed by many distinguished speakers, including our former colleague, Justice Kagan. So it's a great honor to be here. I must say I did not know Justice Scalia as well as many of you here, and certainly not well enough to call him Nino, as some of you do. But I did feel a great kinship with him because of our common interest in foreign and comparative law. Now, some of you may be thinking, excuse me, Scalia and foreign law? Is this the same Antonin Scalia who dissented so vigorously over mere references to foreign law in certain Supreme Court cases? The same Antonin Scalia who debated so vigorously with our former colleague Justice Breyer shortly before one of those cases was decided? Would it be the same Antonin Scalia who was called by commentators at the time a nativist, a know-nothing, and a rampant xenophobe, just to give you some of the more choice epithets that were thrown in his direction? Well, yes, in fact, it was that Antonin Scalia, and it was the same Antonin Scalia who taught comparative law and private international law for 12 years at the University of Chicago and the University of Virginia. It was Antonin Scalia who, shortly after his debate with Justice Breyer, told an audience at the American Enterprise Institute that, Dean Manning, pay attention to this, that comparative law should be a mandatory subject in every American law school. So it was in homage to Professor Scalia and Justice Scalia that I chose the title for my talk today, Who Needs Foreign Law? And not to keep you in suspense, I think the answer that Justice Scalia would have given is that practically every branch of the legal profession could benefit from consulting the experiences of other countries, except judges in constitutional cases. And even there, he had one exception. He was perfectly happy to consult pre-1787 English law in determining the meaning of the United States Constitution. Now, if that surprises you, let me say a few words about the Professor Scalia, the young man who took his first teaching job in 1967 at the University of Virginia Law School. At that moment, all indications were that he was headed for a great career in international legal studies. After he graduated from high school, where he had a love of foreign languages, he spent a year in Fribourg, Switzerland. He went to Georgetown, Harvard Law School. After Harvard Law School, instead of rushing off to a clerkship or a firm, as many of his contemporaries, probably most of his contemporaries did, he took a whole year traveling around Europe on, I think, a traveling fellowship from the law school. He spent most of that year in Germany, where he studied German law at Frankfurt. So he came back to the United States, practiced law for a few years, then went to the University of Virginia, and he was asked by the student newspaper, "What are your specialties?" He said, "Comparative law and private international law. That's where I'm going to do my research." His course materials, which we now have, thanks to the Scalia family, we have his course materials and his other papers in our library here. And last month, I finally had a chance to look at his course materials. And not surprisingly, he used the two leading case books that were available then, our late colleague Arthur von Maren's and Rudy Schlesinger's. In short, whatever else we can say about Justice Scalia and foreign law, he had a well-informed appreciation for it. But 15 years ago, many people got a different impression as a result, largely as a result, of the debate with Justice Breyer and of his dissents in a couple of capital punishment cases at the time. In my remarks today, when I go to a talk, I always like to have people tell me where they're going so that I can see when they're getting close to the end. So in my remarks today, I would like to begin by revisiting that debate. And then I would like to offer some thoughts about 3 areas where I'm sure Justice Scalia would have agreed we could use more attention to foreign law, foreign experiences in this increasingly interdependent and globalized world. So, the Scalia-Breyer debate. Some of you will recall that debate was sparked by really, looking back, just a handful of allusions to the laws and practices of other countries. Scalia's emphatic disapproval of those references, and one has to add, his rather colorful way of expressing them, led many commentators to assume that his attitude toward foreign law was something like that once expressed by Mark Twain. Mark Twain got tired of listening to the preachers of his day, always condemning the devil. And he said, that's not fair. They don't give him a chance to present his side of the case. He can't confront the witnesses against him. That is irregular. That is un-American. It's un-English. It is French. The fact is, though, that when you look back at what Scalia actually said in that debate, it's striking how much common ground they had. And that should not be surprising to us because we all remember Steve Breyer, too, was a person who had a good deal of interest in what foreign countries did. So the disagreement really came down to a single point about the use of contemporary foreign materials in constitutional interpretation. But they agreed that foreign materials could provide useful information about how various legal measures work out in practice, what advantages they may offer, what unintended effects they might have. Scalia once put it, I'm quoting here, you can look to foreign law and say, gee, they did this in Germany and the sky didn't fall. That's certainly a very valid use of foreign law. So when it comes to the use of foreign law in constitutional interpretation, he said in the debate, that's where I get off the boat. He said to Breyer had taken the position that the court, I'm going to quote Breyer here so you can see how narrow their disagreement really was. Breyer said, the court may consider as relevant and informative the way in which foreign courts have applied standards roughly comparable to our own in roughly comparable circumstances. And there was the rub, comparable, as the comparatists here are nod their head. Yes, Breyer, of course, was careful to say roughly comparable. But what Scalia zeroed in on was, in what sense are the constitutional standards of other liberal democracies, let alone other countries, in what sense are they roughly comparable to ours, and in what circumstances? What circumstances can be said to be roughly comparable? Scalia's position was that the context of constitutional decisions in other countries, just the liberal democracies, were so different from our own that the comparability problems were severe and underappreciated by his colleagues. And that position, by the way, finds strong support in a book that is coming out in just a month or two, magisterial 15-nation study by Calabrese and Owen of the constitutional courts in constitutional democracies. It's a 2-volume study, and it provides abundant support for Scalia's concern about comparability. So Breyer, of course, conceded that comparability could be a problem, but he said, quote, if I have a difficult case and a human being called a judge, though of a different country, has had to consider a similar problem, why shouldn't I read what that judge has said? It won't bind me, and I may learn something. There's enormous value in any discipline of trying to learn from the similar experiences of others. Well, what professor could disagree with that? And Scalia did not disagree. Scalia's complaint was not about learning from foreign experience, but about giving it something close to a controlling role in the court's decision-making process, which, as we now know, was how he saw the majority opinion in Roper versus Simmons, a case that was decided just 6 weeks after their debate. And I know that case was in their mind when they were debating, and the division on the court was in their mind. So there was a debate between two sitting justices, followed closely by a split decision, and it gave rise to a flurry. You might almost say an avalanche of commentary, most of it critical to Scalia. But when one reads Roper versus Simmons at this distance of 15 years, I must say that it seems to me the commotion was somewhat exaggerated, and Scalia's position in Roper was often misunderstood. So Roper was a test case on whether Missouri's application of the death penalty to older juveniles violated the Eighth Amendment's ban on cruel and unusual punishments. The death penalty for offenders under 16 had several years before been held unconstitutional. Mr. Simmons was 17 at the time his crime was committed, but in other respects, if you were looking for somebody for a test case, he wasn't really your ideal candidate. He told friends that he wanted to murder someone, and then he and a younger associate went into a woman's home, broke into her home at 2 o'clock in the morning. They tied her hands and feet with electrical wire. They gagged her and they placed duct tape over her eyes and her mouth. And then they took her to a high bridge and dropped her into a river where she drowned. Afterwards, he told his accomplice, don't worry about it because we'll get away with it because we're minors. And he bragged about the killing to his friends. And it was those aggravating factors, actually, that caused a Missouri jury to depart from the usual presumption that the age of the defendant should be taken into consideration as a mitigating factor. So the question that came to the Supreme Court was whether Missouri, by applying the death penalty to older juveniles, was inflicting a cruel and unusual punishment on them as measured by the then test of evolving standards of decency that marked the progress of a maturing society. Now, in previous cases, the court had determined what those standards were. It had measured those standards by looking at the practices of the various states and finding a national consensus. And in previous cases, a national consensus required, quote, overwhelming opposition to a challenged practice, generally over a long period of time. And at the time, 15 years ago, the picture was mixed. There was a narrow majority of states that had rejected the juvenile death penalty, but there were 20 states encompassing 42% of the population that had retained it, treating the youth, as Missouri did, the youth of the offender as a factor to be considered as a mitigating circumstance. Well, Justice Kennedy, writing for the majority, found that mixed picture was sufficient to show a national consensus in view of the evidence of a trend, and considering that even in the states that retained the death penalty for juveniles, it was infrequently used. And in my opinion, the case could have ended right there. And the dissent, if there was a dissent at all, would have been about the details of whether there was a consensus or not. But Justice Kennedy was worried about the weak consensus, and so he added some other language. In fact, he announced a new approach to determining whether a state's punishment was in line with evolving standards of decency. He said that from now on, the evidence from the states would be merely a beginning point for the court's own analysis. And that's where the trouble started. Kennedy said, it was up to the justices themselves, quote, to determine in the exercise of our own independent judgment whether the death penalty is a disproportionate punishment for older juveniles. And then, using their independent judgment, the court majority ruled that Missouri's application to of the death penalty to Mr. Roper was unconstitutional. Now, you may be wondering, where does foreign law come in here? We've got already two issues that divided the majority from the dissenters, or potentially divided the majority from the dissenters. But Kennedy went on in the opinion, apparently in an effort to show that the opinion rested on something other than just the views of the justices. He turned to data on what other countries had done. And he said, the overwhelming weight of international opinion against the juvenile death penalty provides respected and significant confirmation for our own conclusions. Now, when I went to law school, Martha, and learned about cases from Carl Llewellyn, I would call that dicta. But that gave rise to a lot of commentary and a lot of division of opinion. But it was not the principal basis for Scalia's dissent. Scalia dissented on three grounds. One was the weakness of the consensus. One was he didn't like the references to foreign law. But the main reason, he said, was to the substitution of the views of 5 justices for A, the judgment of the Missouri legislature, and B, the judgment of a Missouri jury, that there were aggravating circumstances that required the death penalty in this particular case. And that, he said in his dissent, that was what was in his view, was the, quote, real force driving the majority's decision. And that was the real basis of his dissent. It was Justice O'Connor in her dissent. Justice O'Connor, usually a big fan of consulting foreign law, she thought the majority had gone too far this time, and it was in her view that the majority was using international opinion to make up for the absence of an American consensus. That was her. So I think it's fair to say at this distance, looking back and reading all of these materials for the first time in 15 years, I think it's fair to say that the majority's finding of a national consensus on the basis of a trend and the lack of enforcement was plausible. And in my view, the majority would have done better to end its opinion right there. But since they didn't, I must say that what strikes me as problematic about the majority's use of foreign data in Roper is a point that neither of the dissents mentioned. It is that most of the countries listed in the majority opinion as having abolished the juvenile death penalty did so through the normal democratic legislative process and not through court decision. So in my view, there was a lesson to be learned from foreign law there, but it wasn't the lesson the majority took. It was the lesson that Oliver Wendell Holmes Jr. taught innumerable times, that a judge's own opinion has nothing to do with the right of a majority within constitutional limits to embody its opinions in law. And on that point, it's instructive to compare Roper with another constitutional decision where the court unanimously used foreign law in more than a trivial way to uphold a state law, and Justice Scalia didn't dissent. So this was Washington versus Glucksberg, where the Supreme Court upheld a state of Washington statute mandating, not mandating, thankfully, it was a ban on assisted suicide as reasonably related to the protection of a number of legitimate state interests: preservation of human life, upholding the ethics of the medical profession, protection of vulnerable groups, avoiding the path to voluntary and perhaps involuntary euthanasia. And as evidence of the rational basis for the legislature's judgment, the court cited studies on euthanasia in the Netherlands that indicated that the practice there was not being confined to competent terminally ill adults, and that governmental attempts to regulate the practice had not been fully effective. The court also cited legislation from many European countries making it a crime to assist a suicide. Now, today, Washington does have that statute, but at the time, that was the decision of the unanimous Supreme Court of the United States. So, the question is, was Scalia being inconsistent in protesting the use of foreign law in Roper and agreeing with it in Glucksberg? Well, I would say no, if you appreciate the distinction that was made by Judge Henry Friendly in a famous law review on the use of social science data in judicial decision-making. And Friendly pointed out that it's one thing for a court to use such material as evidence that the legislature's judgment has a rational basis. But it's quite another thing to use social science material in support of the court's own decision overturning legislation. So we think here of the way Justice Harlan used social science material in Lochner and the famous Brandeis briefs. It's one thing to use social science material, and I think there's an analogy to foreign law here, because the foreign law that courts cite is really, I think I could say, more often data and nose counting than it is actual analysis of primary legal materials. So I believe that Judge Friendly's distinction is helpful in the foreign law cases, but it doesn't settle the question of whether the uses of foreign law in a particular case are appropriate, because with foreign law, as with social science material, there are other issues. How do we assess the credibility of the material, of the source, or the study that the judge or the judge's clerk found? It's not like a trial where you can have an expert witness and the expert witness can be cross-examined. And that difficulty is compounded by the one that Justice Scalia harped on, comparability, arising from the ways in which the context in other nations differ from our own. Neither the unique American design for constitutional government nor our distinctive model of judicial review has been widely copied, even by other liberal democracies. For example, the constitutions of most countries are far, far easier to amend than the US Constitution. And in some countries, the court decision can be overruled by a supermajority of the legislature. I can only imagine how disconcerting it must have been for Justice Scalia to hear Justice O'Connor say, as she did on one occasion, and I'll quote here, our Supreme Court should be looking more frequently to the decisions of other constitutional courts, because the American model of judicial review is spreading around the globe. Well, as the new study by Calabrese and Owen shows, judicial review is spreading around the globe, but not the distinctive American model. Comparability aside, there are problems of a practical nature that would arise if references to foreign law would be routine. In the debate with Breyer, and as Charles Fried has pointed out, I think I'll quote his formulation. He says, that would introduce a whole range of materials to the texts, precedents, and doctrines from which the Herculean task of constructing judgments in particular cases proceeds. Litigators would have no way of knowing when, where, and how often judicial minds might wander to faraway lands. And another concern that was expressed by Scalia is selectivity in the use of foreign law. He said in the debate, he was worried that judges might be tempted to manipulate material like that, And Breyer said, oh no, that wouldn't happen. Nobody wants undemocratic judges submitting their view for that of the legislature. But Scalia then pointed out, he gives in to temptation to be a little too colorful. So he says, the judges that like to learn from other countries so much, they take a different, they don't take the same approach to foreign sources that disagree with them on such matters as illegally obtained evidence, regulation of abortion, regulation of speech, public funding for religious education. So he said that their reliance on foreign law is sort of like the person who goes to the cocktail party and looks around and makes a beeline for his friends. So I think one has to say at this juncture that particular temptation is not exclusive to judges. It's not exclusive to any point on the political spectrum. It just seems to be something people do. But this brings me back to the suggestion that I made at the beginning of the talk, which is that it is divergent conceptions of the judicial role that explain why some people got so upset 15 years ago at mere references to foreign law, and others said it's no big deal. The argument between those who oppose and favor the use of persuasive authority in foreign law and those who see little or no harm in the practice is largely about who should decide the most divisive questions in our society when there is no guidance in constitutional text, structure, or precedent. And if one is not troubled when a court majority strikes down a law on the basis of its own views, then probably one is not going to be troubled if the court throws in some foreign material to shore up its opinion. So, although I am as keen as Justices Breyer and O'Connor on the benefits of learning from the experiences of other countries, I'm inclined to think with Justice Scalia that the difficulty of gaining an accurate understanding of foreign law, the burden on judges and lawyers in doing so, the problems of comparability, and the issues of democratic legitimation generally outweigh the benefits to be gained. But when all is said and done, something of a tempest in a teapot, in my view. Cases involving judicial use of foreign law are quite rare. And so now I would like to turn to an area where the use of foreign law has received less attention than it merits, where the risks are lower, and where the potential benefits are much greater, namely in the legislative process. And judging from Professor Scalia's materials, I'm sure he would agree with me on this, that the legislative process is an area where more attention to foreign experience could be helpful, especially when lawmakers are struggling with new and emerging problems or existing problems that our legal system doesn't handle very well. And in that respect, Scalia would be in the company, a very good company, of Justice Cardozo, who exactly 100 years ago wrote an article in the Harvard Law Review. You know, it's great to look at the old Harvard Law Reviews. The short article is really a wonder to behold. The person who says what there is to say and stops. So great. So Justice Cardozo's article was that a suggestion that the US should adopt the practice of several European countries to canvass the experience of other nations when confronted with new or intractable problems. His point was not that there are devices overseas that you can bring over like a new appliance and put an adapter in and plug in and it's ready to go. It was rather that awareness of how other nations deal with new issues can, at a minimum, give us a better understanding of the issues and often can do more, providing insight into how various legal approaches work out in practice, what advantages they offer, what risks or indirect consequences they are likely to entail. And in fact, that type of inquiry is mandatory for the British and Scottish law commissions. They are required by statute to obtain such information as to the legal systems of other countries as it appears to the commissioners likely to facilitate likely to facilitate the performance of their functions. American legislatures are still far from routinely expanding their field of inquiry to that extent, but they have on occasion drawn upon foreign experience with impressive results. The probate reforms that greatly reduced the expense and delay of probate for small and middle-sized estates, those reforms were introduced by mostly German and Austrian emigre scholars who came to the United States in the 1930s and marveled at the cumbersomeness of probate for people with modest estates. Another example would be Workers' Compensation Acts, almost all based on English and German statutes. But I want to mention in particular one of the most successful American instances of outright legal borrowing, and one of the least known. In fact, it was deliberately not advertised. Carl Llewellyn, as chief reporter of the Uniform Commercial Code, borrowed freely from German models, both as to form and as to substance. But for obvious reasons, when he went around the United States, getting every state but Louisiana to adopt the Uniform Commercial Code, he wasn't going to advertise where that interesting and quite unusual statute in terms of the form, the general part and the special part, and in doubt do this and that. He wasn't about to advertise where those ideas came from. And in that connection, I might mention that Americans could also learn from foreign models a little bit about statutory drafting. Do you ever read a statute and wonder, who writes these things? How is it possible? Dean Manning, I don't know, but I think that there is no American law school that has a course on statutory drafting. Maybe there was one at Chicago for a while, but it's something to think about. So, as a practical matter, law revision bodies, unlike courts, can eliminate some of the problems with use of foreign law because they can target the areas where they're going to invest their time and their research, where they have reason to believe that they'll get return for their investment. And we see that today, and in fact, many people on the faculty of the law school here are engaged in really useful exchange with scholars in other countries on approaches to these vexing problems that are arising in rapid technological developments, biotechnology, surveillance, and it'd be crazy if they didn't do what they are doing and take a look at what ideas there are. So now I want to move very briefly to another area where some knowledge of foreign law is often beneficial to American lawyers, and that's, of course, the increasing proportion of practitioners who have to operate in an increasingly globalized legal environment. A lot has changed in that respect since I, as a young lawyer, joined the litigation department at Mayer, Brown and Platt, and I asked for leave to do some pro bono work with the Chicago Bar Association's Defense of Prisoners Committee. And I had the great good fortune to get picked as the assistant and second chair to one of the celebrated Chicago trial lawyers. I was so excited. We were at our first trial, jury trial, and I watched as the great man went up and began the voir dire. And he stood behind the defendant. He kind of in a protective posture with his arms back of the chair. And he said, "Do you know, Mrs. Smith, the first juror, do you know that the United States is the only country in the world that wraps a defendant in a presumption of innocence that remains with him for the entire duration of the trial?" So, being young and rather full of myself, we're at the first recess, and I said, Jim, you know what you said in there about the presumption of innocence? Well, actually, every liberal democracy has a presumption of innocence. Even the others have something like it on paper, usually. And he seemed very interested in that, at least I thought so, because he said, no shit, I didn't know that. So we go back into the courtroom, and he takes his position behind the defendant. He says to the next juror, do you know that the United States is the only country in the world that wraps this defense? So those were the days when most practitioners didn't have much reason for getting involved with foreign law. But today, attorneys with a little knowledge of foreign law and a lot of knowledge of foreign law are increasingly in demand. And firms always need local counsel for foreign business, but you have to have somebody who can communicate with local counsel and who can be persuasive in foreign settings. And that brings me to something that I want to say to the students here who are in the process of selecting courses for next year and the year after. If there is room in your schedule, please consider the magnificent language learning opportunities that are offered at Harvard University, just a few steps away. I've taken some of these courses. They are wonderful. And there maybe is a little hole in your, I don't want you to displace anything important, like comparative law, but it's a golden opportunity, and I would feel remiss if I didn't mention it. In fact, one of my students spent the January term at an international institution in Geneva, and when he came back, he wrote his report, as our students are required to do, and he said that the experience made him aware, made him think about how useful it would be to know another language. He said, if I want to continue in international advocacy, Google Translate just doesn't cut it. So now, having indicated, I have to take a little break here because I'm going to talk about comparative law and legal education. You have to get ready for this because the dean is right there. So I'm going to turn very briefly to the place of foreign law and comparative law in legal education. There really has been, over the time that I've been in law teaching, a great burgeoning, most welcome of international legal studies. And most law schools have greatly expanded their offerings in public international law, international tax law, international business law. But it has never been easy to find professors, American professors, who are willing and able to teach comparative and foreign law. Harvard has been more fortunate than most in that respect, and it hasn't been easy to find capable professors from other countries who are willing to teach in the United States. I remember that the University of Chicago used to draw very heavily on German scholars, and there's a story that way back in the earlier part of the 20th century, the president of the University of Chicago wrote a noted German scholar and said, it was a telegram, and said, we offer you a post at the University of Chicago at $5,000 a year. Do you accept? His telegram came right back and said, yeah, wo ist Chicago? So it's a little, if it were only so easy now. But having said that, there are good reasons why the study of foreign and comparative law is more needed than ever in a multipolar world. At present, there are two powerful and opposing trends that are transforming the global landscape. On the one hand, there's a universalizing principle that has strong appeal in many quarters. On the other, there's an impulse toward decentralization that manifests itself in various movements for regional, local, and national autonomy. One force presses toward unification and standardization, the other toward pluralism and diversity. There are constant struggles over whether some regional, national, or local arrangements should be modified, and over the extent to which those arrangements and the values they represent should be protected. In that environment, comparatists, with their attention to particularity and their inclination for mediating between the general and the particular, comparatists have much to offer. As Notre Dame's Paolo Carrazza has pointed out, I'll quote here, comparative law has the paradoxical capacity to deepen our understanding and appreciation of the particularities of legal traditions, while at the same time helping us to transcend our differences by relating them to one another. Carrazza argues for an integrated approach that values the freedom and integrity of local cultures without reducing particularism to pure devolution, and affirms internationalism without the temptation for a superstate or other centralized global authority. There would be much more to say on that subject, but again, having the students who might be here in mind, I'd like to close with just one more remark about the benefit of comparative study. Because I think if you asked most people who study foreign and comparative law, they might mention the things that I have mentioned, but I think what most of us would say, it's a wonderful source of ideas. And it's so much so that it gives you a lasting fascination. And I think a comparatist in another field, the great historian, the French legal historian Fernand Braudel, put it very well. He said, if you go, he's in France, he says, if you go to England and live there for a year, you won't know much about the English. But when you return, he says, in the light of your surprise, when you come home, you will see everything in a new light, and that which had been hidden to you because it was so familiar. I think he really captures what comparatists feel, the sense of you don't really understand your own system unless you have a sense of what other systems are like. And in that respect, I just want to close with the way that T.S. Eliot put that point in the 4 quartets. We shall not cease from exploration, and the end of all our exploring will be to arrive where we started and to know the place for the first time. Thank you. Thank you. Now, as Dean Manning said, if Justice Scalia were here, I know he would have found many bones to pick. I know that because I was once at a symposium at Princeton with Justice Scalia and Ronald Dworkin and I forget the other person. And I thought that my presentation was pretty much agreeing with him, but of course, he found tons of things to argue about. So there's now a moment for questions, and I'm happy to hear from you. Hello, yes.
Hi, Professor Glendon. Thanks for that wonderful presentation. I'm curious, what do you think might be some of the deeper reasons for the more inward-looking or sometimes insularity among American legislatures, and what do you think can be done to ameliorate, especially among the younger generations?
Well, it really goes back to the legal world that I entered as a young lawyer. For a long time, you just didn't have to know. And there were lots of other claims on your time. They used to say that studying foreign law, or they used to be put to us who took a couple of years to do it, they used to say, well, that's a luxury. It's like a taste for fine wine. It's okay to appreciate it, but you don't want to get into it too deeply. So I think I would really answer your question this way, that it's not what accounts for the insularity so much as why it is taking so long for American legislators to understand the benefits. I mean, thinking of the areas of, rapid development in technology of all sorts. You really need all the brains that you can get on that. And maybe in that connection, I could mention, a difference between, why did comparative law become such a well-developed enterprise in Europe? Well, when we want to know what our neighboring states do, we just consult the law of our neighboring states. But Europeans who were required by trade and commerce to know something about their neighbors, they really had to learn about other legal systems. And if you're a continental European, you had to know about England, which those old emigres, I had the good fortune to be educated by some of them, those old emigres used to say, looking at the common law, it's such a mess. How do you ever even get a handle on it? No sense of, statutory drafting, for example. So I think the mystery, to come back to your question, is why aren't we doing more of it, as Justice Cardozo said we should 100 years ago? Yes.
Foreign law to an international law to the U.S. Constitution itself be a question of constitutional interpretation?
Well, there I would agree with your former boss, that, as he said, there's no rough comparability. You can look, he said, look at it, learn something. No problem with that. But if you're using it to actually give meaning to clauses of the Constitution, you are at the outer edge of your own legitimacy.
That was so beautiful and generous and funny, also a talk. My question actually goes to subnational. We have state Supreme Courts. Many of the justices are elected. If they refer to international sources or foreign sources, is there a legitimacy problem? I'm really focusing then on, is it the election or is it the judicial role that makes the consultation a problem?
I think at the state level, the problem is aggravated by difficulties of access to the material and limited resources in terms of clerks and research. But basically, I think the answer that I would give is that it's interesting to, Breyer was right. Why can't I read? Why can't I learn? Those of us who find learning about foreign law exciting, fascinating, we'd be all for it. But if you use it to interpret the state constitution, you've got the same problems that you have with the federal constitution. That first of all, there are the problems of comparability, and then there are the problems of, if you are substituting your judgment as a judge for the decision of the democratically elected branches, that's, and unless there's, as Scalia would say, unless there's constitutional text, clear constitutional text, language, precedent, you're skating on the edge of your own legitimacy. And right now, in a country that is in such turmoil about legitimacy, probably wise not to exacerbate it. Yes?
Thank you very much. Many of the other foreign nations have more robust language protections and the ability to use different languages in government. Should we be thinking more about that and language rights in the United States to expand interest in foreign law and in languages?
Well, that's a very interesting question because that very idea is being discussed at the State Department, and I am hoping that it's going to result in some new, more effective, more intensive programs along those lines. Yes, you know, you can almost always find someone in any group when you're traveling who speaks English. But if you only interact with the people who speak English, you are not getting a full vision. And it's a concern even with our diplomats. You know, we shouldn't be, well, I think I better not say any more about that. Charles.
When you look at clauses in the Constitution like due process, equal protection, but particularly cruel and unusual punishment, and you think, unusual? Well, to quote the Declaration of Independence, doesn't it befit us to have due respect to the opinions of mankind? That's what the Declaration of Independence says.
Yes, although the Declaration of Independence, that language was pretty much directed at keeping other nations out of our business with England. But the Declaration of Independence does speak in universal terms. The United States was the first country in the world to be founded on the idea of a universal, all men are created equal and have certain unalienable rights. So I don't have any problem with consultation and in the, well, you know that due process clause, you know what Justice Frankfurter said to the Indians who were drafting a new constitution in 1948? He said, better leave due process out. It's subject to too many interpretations. In the very open-ended clauses, due process, equal protection, again, I think it's a question of how far you think the court should go toward the outer edges of legitimacy. It is, or as Scalia would have said, we should never forget, it is the Constitution of the United States that we are expounding.
Thank you, Professor, especially for your remarks about the academic job market. They definitely hit home. I'm just wondering, when we decide that foreign law is worth examining and worth studying, there's still a question of what foreign law to study. And do you think that the current approach to foreign law is more impermissibly Eurocentric, or do you think there's some value in only focusing on jurisdictions that are similar to our own and jurisdictions that are more or less, well, quote unquote, respectable?
It's a great question, and it is the reason why when legislatures consult foreign law, as they do, as you know, in other parts of the world, it's not just foreign law in general. Where do we think we have the best chance of finding some useful ideas? Now, useful in what sense? Useful in solving a problem that we haven't solved or we're struggling with? There you would probably look to the laws of countries that are at comparable levels of social and economic development, and that would certainly not be limited to Europe. So it would depend, that's why the people who cite risks of comparative analysis overlook that the legislature can decide that question. Where is it best to look and where not? As you know very well. Thank you so much.